agreed to by the parties, list this matter after 4 weeks.
Apply, Your Lordship.
May I please, Your Lordship? I beg to mention item number 6. Your Lordship, the conducting counsel went for the funeral, Your Lordship. That's why we want a 1 week. I pray for 1 week time, Your Lordship.
Let it come after 2 weeks, Lord.
You're for respondent number
2.
2.
Yes, Your Lordship.
Mr. Legal Counsel, appearing for the respondent number 2, has sought for accommodation on the ground that the conducting counsel is indisposed. The same not be objected to by Mr. Legal Counsel for the appellant. That is adjourned. This is after 2 weeks.
Much obliged, Your
Highly
Lordship.
obliged.
Daily list item number 1.
Lordship, I have received the show cause filed by them, Lordship. The Lordship,
Yes.
Lordship, here the matter is for continuation of delay, Lordship, on the judgment, Lordship. The judgment, not on the execution, Lordship. And on the show cause they have filed, Lordship, I am praying, Lordship, that the lower court's record may be called for, because the judgment, the award, everything is in the lower court record, Lordship. So I am praying that if the lower court records is called for, then we will be in a better position, Lordship.
Low court records are here.
No, Lordship.
This matter is connected to the other one, isn't it?
Other one, but the case records are different, Lordship. Though it is connected with the other one, but the case record is
Proceedings are different.
no, proceeding is same. The witnesses are same, everything is same, but the records, the order sheet is different,
The
Lordship.
parties also are different.
Oh, exactly.
So now, Your Lordship, we're in the stage of condonation. If Your Lordship rejects, then the records are not required.
Yes, we'll come to that. I'm just wondering because I thought the records are already here.
No, Lordship. The records are
For
not.
condonation of delay, why do you need records?
Not required.
Lordship, for condonation of delay, records are not required. But for condonation of delay, I am just relying on one judgment, Lordship, recently passed by Supreme Court, Lordship.
What are your, you see, first you state your facts, state your case.
Your Lordship,
What are your, you see,
whether the judgment is...
What are your grounds for seeking
Yes,
condonation?
Lordship, I am coming, Lordship. I am coming to the grounds, Lordship. Lordship, here what happened, Lordship, on perusing the other case record, Lordship, it was it came to the light, Lordship, that the award was never a part of the reference. When the judgment was also passed, award was never a part of the reference, Lordship. So the award was not in the record also. Without the award amount, without the copy of the award, Lordship, the lower court has, instead of referring the matter to the collector for sending it in a proper way, the lower court has gone to the extent of the merit and has passed the order, Lordship. So once the award is not there, the lower court has no jurisdiction to go into the merit of the case, Lordship. The Lordship, here, when we came to know from the other case record that the award was not there as a part and parcel of the record, Lordship, we have come before this Honorable Court, Lordship. And by that time, execution was also filed by my learned friend before the lower court. So the execution's order was also passed. But Lordship, if the judgment itself is defective, whether the execution can be entertained, Lordship, if the copy of the award is not there in the first place, Lordship, then whether the judgment is at all entertainable, Lordship. Furthermore, Lordship, when we received the copy of the award filed in the other case, Lordship, on perusal of the award, it was also found out that, Lordship, neither the company's name nor the petitioner's name is reflected in the award, Lordship, in the list of the awardee. So, Lordship, if in the list of the awardee, the petitioner's name is not there, the companies for which the main confusion arises, Lordship, even the company's name is also not there, whether the judgment at all is a valid judgment, Lordship. Instead of sending the matter to the to the collector for sending it in a proper way, Lordship, to the award which is granted to the petitioner or the petitioner company, the copy of the award has to be reflected, and the copy of the award also has to be there, Lordship. So entire the trial has fallen apart, Lordship. So I am before this honorable court and on condonation of delay, Lordship.
But you see, it was you were a party before the
Lower court.
trial court.
Yes,
very much.
We were the party.
You had filed your written statement.
Yes, I have filed my written statement.
Had you adduced evidence?
No, Lordship. Because I am a beneficiary in this case.
Whatever
so,
the case,
my
opportunity
evidence,
was given to you to adduce evidence, you have declined.
yes, Lordship.
But you have filed your.
I have filed my written statement. Even I have relied on the argument of the collector, because my argument is mainly based on the collector's argument, Lordship. But, Lordship, once the reference is sent to the court, Lordship, though I am a party, but it was not my knowledge that the award copy was not there. Once everything was scrutinized, Lordship, then only we came to know that the award copy is not there. Once the cases were scrutinized. Lordship, the main base of the case is the award. So, Lordship, the delay may be condoned because I have explained my the reasons for the delay. Because and in one of my judgment also, Lordship, I am relying. It is a very recent judgment, Lordship. It's passed by Supreme Court, Lordship. In page 2, Lordship, third line, Lordship.
Yes.
The court, while examining the plea of condonation of delay, would not consider the length of delay for condonation of length of delay, but the cause shown for such delay. If the cause shown is sufficient, here I have shown sufficient ground, Lordship, irrespective of the period of delay, same would be condoned. On the other hand, if the cause shown would not fall within the definition of the sufficient cause, irrespective of the length of delay, the same would not be condoned. At this juncture, we are reminded of the judgment of this court in the case of collector land acquisition, so and so, wherein the court held that the legislature has conferred the power of condonation of delay in the hierarchy, and as such, the liberal approach is adopted on principle, as it is realized that ordinarily a litigant does not stand to benefit by longing an appeal late. Refusing to condone delay can result in a meritorious matter being thrown out at the very threshold and cause of justice being defeated. As against this, when delay is condoned, the highest and that can happen is that a cause would be decided on merits after hearing the parties. Everyday delays must be explained does not mean a pedantic approach should be made. Why not every hour's delay, every second's delay? The doctrine must be applied in rational, common sense, pragmatic manner. When substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred for the other side, cannot claim to have vested right in injustice being done because of a non-deliberate delay. there is no presumption that delay is occasioned deliberately or on account of culpable negligence or on account of or on account of malafide, and a litigant does not stand to benefit by restoring to delay. In fact, he runs a serious risk. It must be grasped that judiciary is respected not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustice and is expected to do so. Further, no litigant would stand to benefit by approaching the court belatedly. In the instant case, when the facts on hand are examined by applying the principle enunciated by this court referred to supra, it would emerge from the records that the cause shown for delay is that the applicant not have been made a party. That is different, Lordship, where the applicant has not made a party. But Lordship, here in the case which Supreme Court has taken, Lordship, is of the land acquisition matter only, Lordship, and also it is the part and parcel when the delay which I have the condonation, the reason for condonation of delay which I have shown which I have placed before this court is a valid ground, Lordship. If the records are scrutinized, Lordship, on scrutinization of records, Lordship, it is found that the award is not there, Lordship. So I have explained the reasonable grounds, and as such the delay may be condoned, Lordship, because here in the entire judgments where the Supreme Court has taken has condoned the delay in this instant case, has also taken the reference of the land acquisition case. So, Lordship, it is also a very vital that once a party, because I am the beneficiary in this case, I have to pay, Lordship. So I am not disputing that I will not pay, but my only contention is that the entire proceeding should be in a very in a reasonable manner. If the award is not there, if the award the petitioner, neither the petitioner, first the confusion arose, Lordship, where the petitioner company or the petitioner himself is the liable person, because in the judgment, Lordship, in condonation of delay, I have come for the judgment, Lordship, because in the judgment, Lordship, the name of the judgment holder is the father of the present petitioner, but in the reference made, Lordship, it was the company. So if had this been so, why not the petitioner had approached the lower court, the claimant has approached the honorable court lower below to rectify the judgment? Because if in the judgment the company's name is not reflected, and they have in the execution proceedings they have come as a judgment company as a judgment debtor, though on representing by the director, but the fact remains that the lower court's judgment, the father was the judgment debtor. So, Lordship, the delay may be condoned and lower court's records may be called for, Lordship, because the entire proceedings will be in the lower court's record.
So the matter before the special judicial officer, Nongpo, was for enhancement of the award.
Yes, absolutely.
Enhancement of the award.
Old Act or New Act?
Whole act.
So Section 18.
Section 18.
So reference was made under Section 18.
Your Lordship,
Yes.
Section 18.
Order passed under Section, taken to account Section 23.
Pardon, Lordship?
Said order was passed.
Yes.
Judgment was passed, taken to account Section 23.
Section 18, Lordship.
Done?
Yes.
Finish? Your Lordship,
You are the
I'm the opposite party number 3 in the condonation application.
No,
I'm the claimant before the trial.
okay.
Your Lordship, as per the last order, I was supposed to file my show cause to the condonation and an affidavit bring on record certain documents. Now, before I go into the condonation application, Your Lordship will kindly take up the affidavit filed by me.
Lordship, the affidavit is, though on condonation, Lordship, my condonation is specifically on the judgment, not on the execution, Lordship. Not on execution, Lordship.
He has filed this affidavit.
Your Lordship.
You have not chosen to file any rejoinder, or rejoinder is not required.
These are the documents which I have enclosed are the judicial orders passed by the court. So what has happened here, Your Lordship? The judgment was passed way back in 2020. Thereafter, no execution case was filed. It was only last year that we filed the execution case in the month of September, October. Thereafter, the matter proceeded. Then there was some confusion with regard to the claimant's name, because in the judgment is reflected as Raj Diora. So accordingly, I had filed an affidavit bring on record to clear those clarifications before the execution court. Now, Your Lordship, I'll take Your Lordship to the affidavit which I have filed, that is at page 7.
Yes.
Because at that time, when the matter was before the collector, the claim under section 18 was filed by the manager of the company, that is Rajkumar Diora. So thereafter there was a confusion, so I filed an affidavit clarifying that because Rajkumar Diora expired in the year 2020 after the judgment was delivered. So naturally, Lordship, when the execution petition was filed, the director has come before the execution court, who is the son. So I have placed on record before the trial court the appointment of the son as a director of the company way back in 2000. So that clarification was cleared. And accordingly, Your Lordship, I'll take Your Lordship to the appeal. Your Lordship, that is at page.
What was the order passed on?
I'll take to that.
What was the order passed on substitution?
Lordship, I'll take to that order, Your Lordship. The order will find place, Your Lordship, at page 114 of the memo of appeal. Your Lordship, I'll read paragraph 6 of the order, page 116. Page 116, paragraph 6.
Yes.
Learned GP representing the District Collector OP number 1 and Learned Counsel for the Project Director National Highway Authority of India admitted that they have not preferred any appeal against the judgment decree dated 11/3/2020 passed by this court. Learned counsels for the opposite parties 1 and 2 further submits that they have no objection to the execution petition filed by Rohit Kumar Diora, son of late Rajkumar Diora, director of Sri Radha Creation Private Limited. However, Sri Rohit Kumar Diora should submit his undertaking on that behalf. Further, both counsels agreed that the calculation of the award as submitted by the counsel for the decree holder is correct. Now I'll come to paragraph 9, Your Lordship. That since both the judgment debtor and the objection to the instant execution filed by the decree holders, or has no objection to the instant execution filed by the decree holders, This court is inclined to allow the execution petition, and the decree holder is entitled to receive an amount of so and so from the judgment debtors. This court hereby directs the judgment debtors to pay the amount within a period of 15 days, and the same shall be deposited before this court, to which the same will be handed over to the decree holder on the next date. Now, Your Lordship, this is at the stage of the execution. They have admitted, they have given them no objections. And most importantly, Your Lordship, it was their submission that even if we receive the amount, we should submit an undertaking. Why, Your Lordship? The agreement was that, assuming that the amount has been wrongly paid to me, I can refund the same. That was the understanding. And that is why the Honorable Trial Court had made a specific in the order, Your Lordship, that submit his undertaking on that behalf. They have agreed to all this. They have admitted they have not filed an appeal. They had no objections to the execution till that stage. Thereafter, Your Lordship, there was a next order which has not been enclosed in the memo of appeal. That is why, Your Lordship, I have filed an affidavit bringing on record the order. Now, Your Lordship will take that order. That is at page Annexure 1, page 5 of my affidavit. The order which I have just read was passed on 29/5/2025. Now, Annexure 1, page 5, Your Lordship, kindly see at paragraph 4. Paragraph 1 is case record. Paragraph 2 is the case is fixed today for report. Paragraph 3 is Srimati Z. Binong, learned counsels for the collector. Now, most importantly is the paragraph 4. Srimati so-and-so, my learned friend here, the learned counsel for the OP number 2, NHI judgment debtor, is present and prays for 10 days time in order to deposit the amount of rupees so-and-so. My Lordship, they have prayed for time also to deposit the amount. Now, my submissions, Your Lordship, is that after all these proceedings have been admitted by them before the trial court, can they come and take a U-turn and file an appeal? That also on a submission which was argued by the other petitioners on the ground that the award has not been enclosed. It's only on the submissions. Now we are not clear whether the award was there or not. Now, based on their submissions, they have based the grounds in the condonation application. And kindly appreciate, Your Lordship, that the delay is not a year or two. It's 1800 days, more than 1800 days. There's no sufficient cause. There's no good grounds to condone the delay. Most importantly, Your Lordship, they have suppressed this particular order whereby they have prayed before the court that they will deposit the amount within 10 days. So, Your Lordship, when there is a consent, when there is an admission on their part before the trial court, can they come and turn around and use a ground which is in the other case, which Your Lordship has not taken up entirely the hearing, whether the records are there or not, whether the award is there or not. On that ground, they've come and trying to seek a protection to condone a delay of more than 1800 days. And more importantly, the suppression. So my humble submission, Your Lordship, since they have admitted, since they had no objection to the execution, without going to the condonation application, and most importantly, the manner in which they have abused the process of court. This is a clear case of abuse of process of court. In one court they say something and the High Court come and say something. That's why, Lordship, before going to the condonation, the instant case has to be dismissed. And Your Lordship, my learned friend has made a submission that before the trial court, they have filed the written statement. In fact, it's not true. They have never filed before the trial court. The only petition that they have filed before the trial court is a written argument. Now taking a protection on the ground taken by the other petitioners in the other case, at this stage, in my humble submission, Your Honor, they cannot take a U-turn, number one. Number two, they were not diligent before the trial court in ensuring whether the award is there or not. Now they've come at this stage. Thereafter, before the execution stage, they have admitted that we have no objection, prayed for time to deposit the amount. The judgment which was relied by my learned friend, I may be served with a copy. I would like to read that again. Just give me a copy.
There's only one copy I have.
My learned friend has relied on the particular judgment at page 2. I'll read that again. Yeah. The court, while examining the plea for condonation of delay, would not consider the length of delay, but the shown cause for such a delay. Where is the sufficient cause shown in the application? Your Honor? Kindly examine. If the cause shown is sufficient, kindly examine also whether the sufficient cause is there in their condonation application. Irrespective of the period delay, same would condone. On the other hand, this is important, if the cause shown would not fall within the definition of sufficient cause, irrespective of the length of the delay, same would not be condoned. So here is a case where, Your Lordship, there is no sufficient cause made out, and it will not fall also within the definition of sufficient cause if no sufficient cause has been made out. So my humble submission, Your Lordship, firstly, it's an abuse of process of court, and there's no good grounds, no sufficient grounds made out in the condonation application, warranting condonation of delay, and there has been a suppression of material facts whereby the order which they have prayed to deposit the amount has not been enclosed in the appeal. And Your Lordship, I will not advise them, but they have other remedies which the Honorable Supreme Court has held in such a situation. So in my humble submission, in view of my submission, Your Lordship, I pray that the submissions will be considered and their entire case, whatever they have filed, should be dismissed.
Lordship, what my learned friend has submitted, page 79 of my appeal, Lordship. Page 79 of my appeal order, Lordship, it is. Paragraph 5. Lordship.
Yes.
Yes, para 5, Lordship. O.P. Nahai also contested the case and filed written statement, Lordship. So I have filed my written statement, Lordship.
This is the impugn order.
It is the impugn
Even
order,
that will
Lordship.
not support them, Your Lordship. They were
Lordship.
negligent before the trial court.
Lordship, furthermore, Lordship. Lordship, in their the affidavit, Lordship, we have raised repeated objections, Lordship, because of but our objection was thrown in the dustbin, Lordship. Because annexure 1, Lordship, if the affidavit.
You have
It's a judicial order, Your Lordship. They cannot
but
say that.
Lordship, see, Lordship,
you have raised objection, before the
Lordship.
special judicial officer.
Yes, Lordship. We have raised objection, Lordship. Thereafter, they have come with the affidavit.
See, raise objection where? At the time of hearing.
Pardon, Lordship.
Raise objection at the time of hearing.
In the execution case, Lordship.
Execution case.
Is execution in the reference also we have filed our written statement which says that we have raised objections, sufficient written statements, and Lordship, in the time of execution, Lordship, if the annexure what my learned friend has stated, affidavit to bring on record, Lordship, annexure 1, Lordship, the affidavit. Lordship, Annexure 1, Lordship. Z. Binyong, learned counsel for the OP collector is present. Counsel has submitted there is some confusion with regard to the claimants, and there are two names that has appeared, one Rohit Kumar Deora and other Raj Kumar Deora. So we have raised objection. Now further, Lordship, I am supplying the copy of the lower court order, Lordship. Date 7/5/2025, Lordship.
Yes.
Last paragraph.
Yes.
Both the OPs have filed their replies in respect of the affidavit filed by the decree holder. So we have, after filing the affidavit filed by them, Lordship, we have also filed the reply stating the objections, Lordship. We have repeatedly objected, but our objection was never taken into account, Lordship. And the order was made forcefully, Lordship. Even this is not an open court, or the Annexure 1 is an open court order, but the judgment, the execution main order is not an open court order, Lordship. It was passed behind us, and then the order was dictated before the honorable court. So we were in a, when we were repeatedly objecting, when their affidavit was filed, we were objecting. Even in when the execution on the subsequent day, on the 16th, when the court was pressurizing us to deposit the amount, because, Lordship, there is also a ground, Lordship, why the lower court was literally pressurizing us, because for execution it is only 6 months to dispose the case. The lower court is also under compulsion. We are not saying that the lower court should not have taken that ground, but lower court is also under compulsion, because within 6 months lower court has to finish off the case. And when under pressure, if the court is under pressure, obviously sometimes the court may take wrong decisions also, because it is the execution is when Rajkumar Deora, if we are to release the money, Rajkumar Deora is not there. Rajkumar Deora is the judgment decree holder. They have never came before us to the court informing that Rajkumar Deora has expired. Only during execution we came to know that Rajkumar Deora has expired. More so when the entire proceeding was before on a subsequent matter before this honorable court, we came to know the entire the case which is based on the award is also not there. Lordship, this is a very tricky matter. So that is why I am saying, Lordship, if the delay is condoned, Lordship, and the lower court records is called for, we will be, now what my learned friend is submitting, that award, he is also not aware of the award. Had it not been on him also to check, the award is not there. Award, the main case is his case. He has to suffice the court that he has a very good case. The award, copy of the award, which is very vital for the lower court to pass a judgment, is not there.
Please, Your Lordship. My learned friend here is making an allegation against the court, firstly, Your Lordship, saying that the whatever the objections has been thrown to the dustbin. That's not the case. The matter was heard in their presence, and the order was passed. If she is aggrieved by that order, they have a remedy, but they cannot make that kind of submission before this court, saying the court did not listen to us. It was their submission, and it's a judicial order, Your Lordship. And, Your Lordship, regard to the claimant before the collector, he passed away in 2020. That is why I brought on record an affidavit that there's a son who is the managing director, who was the managing director of the company since 2000. I've enclosed a copy in the affidavit to clarify everything. And the court says that you have to give an undertaking. Why? Why? Because, Your Lordship, the father was a manager, the son is the managing director. Now, if the compensation amount is paid, Your Lordship, it will not be paid in their names. It will be paid in the name of the company, Your Lordship. It will be paid in the name of the company, Sri Radha Creations. That will be credited into the account of the company.
When have you filed this application? June.
I have also enclosed at page 14, Your Lordship. Page 14.
See, Miss, when this order was passed,
Lordship.
16/6/2025 was passed, where you have very, very clearly admitted that the amount would be deposited. If you are aggrieved by the execution proceedings, have you preferred any application for stay of the execution?
Lordship, stay of the execution, Lordship, no Lordship, because we were coming before this honourable court, Lordship, that during that time, Lordship, we were also
True. but
approaching.
What you could have done is, you see, you could have firstly approached the execution court, sought for a stay, and then press your other remedies which are applicable or available to you under the relevant provision of law and procedure. But instead, on 25th, see, and this order says fixed 26/6 for the next date.
Lordship, the day where we already.
Now, you have filed this application on 25th before this court.
Lordship, we have already filed. Lordship, initially we came before this honourable court, but due to some clerical mistakes, Lordship, we were
The point is, your first approach should have been the execution court. Whatever order is passed by the execution court, then you can come. That's up to you. Come by way of revision, come by way of appeal, whatever is available to you under the procedure.
And Your Lordship, kindly in my affidavit, page 14, at the time before the collector, the notice was issued at the name of the company. Why are they making a hue and cry about the name? Compensation will be paid to the company.
That objection should also have been raised,
It should have been raised before the execution court also.
before the execution court.
Lordship, we have raised before this execution.
No, not on the ground that on
Whatever
the
you have-
enclosure.
If at all you have raised this issue, an order must have been passed. If that order is not, according to what you feel it ought to be, you could always prefer again appeal or revision. You have not done that. You cannot just say, we have said so, it is not done.
That is
But that is not
very-
Lordship,
that is
Lordship,
not the way
Very
procedural
unfortunate, Your Lordship.
procedural law is applied.
Lordship, if the lower court's record is called for, Lordship, we have raised lot of objections, Lordship.
No, you may have raised obtained
Lordship,
objection.
the replies were
You
also.
see, what is material? Listen here. You may have raised 101 objections. What is material is the relevant order. What is the order wherein your objection were taken into account or not taken into account? If not satisfied, you have remedies. You have remedies under, again, I keep repeating the same thing, under the procedural law of appeal, revision, whatever. You have that remedy. You also have the remedy of seeking for a stay of the proceedings, execution,
Lordship,
whatever.
we have-
that
we-
you have not done.
Lordship, we have prayed before this honourable court for staying the proceedings. Lordship, the condonation is here.
That should have been done before the execution court,
Execution
because the
court.
provision is there.
Lordship, now the
Lordship,
since
I don't know at this point of time whether you,
Lordship, the delay.
because you see whatever the delay, you see what the judgment that you have cited is what is an accepted or well settled principle.
Lordship,
That is, it has been said so in a catenary of judgment.
Lordship.
The court has no quarrel with that. If you have quality costs, but
Lordship,
the fact is that your conduct has to be looked into.
Lordship,
You cannot blow hot and cold at the same time.
no, Lordship, I have stated, Lordship, that if preferring a judgment. This continuation is not on execution, Lordship. This continuation is on
Exactly.
judgment, Lordship.
Exactly.
And the judgment was passed, Lordship. The judgment was passed, Lordship, without taking into the consideration of the award, Lordship. If the award is not there, Lordship, in the case record,
Even that also, see, even for that also, you are at fault. It is incumbent upon you to go through the case record, to go through the papers available. You are privy to that. You are a party. You should have realized that at the relevant point of time, which you did not. So how can a court help you? Because of your own negligence, it cannot help you.
Lordship, the award which was, if the judgment
Exactly.
is a defective judgment,
See,
Lordship,
that
but the base remains that judgment is a defective, Lordship.
that judgment may be defective,
Absolutely, Your Lordship.
and the court will examine that aspect of the matter. But the fact is, why would it take you so long to realize that?
Yes.
When all along you've been participating, see, assuming as if the award is already there, even to the stage of execution. And admittedly, these are your own words. You have made a commitment for the court, the execution court, that you will deposit the amount. Whatever the case may be, whether the amount is handed over to the rightful person or not, that remains to be seen.
And that will execute an indemnity bond, Your Lordship.
Lordship, if the
Your Lordship, I am just a minute. It's not a stage where execution case has not been filed. It is a situation where the petitioners have come challenging the judgment. Till that stage, it's understood. Now we are in the stage of execution, whereby they have prayed to deposit the amount, whereby they said no objections. They have consented to everything.
Exactly.
Can they come at this stage blowing hot and cold, as the Lordship has rightly pointed out?
Lordship,
I think you first examine, you think it over and see what are your available remedy. You go through the CPC, you go through precedents and authorities and see.
But the Lordship,
I
after
will
they
not-
file
I-
before
I
this
will-
court, I think so it's too late in the day for them to do.
I will not pass an order now. I'll give you an opportunity. You think it over. We'll take up this matter on 15th
15th
Tuesday.
Tuesday, Lordship.
You have not been able to convince the court, but I will still give you that chance
Obliged, Lordship.
because the court also has its obligation. Mr. Sen, you have anything to say?
No,
You're just the conduit. Heard Ms. P. Charlie, Direct Counsel for the applicant.
A long time appearing.
Who has submitted that MD what Ashwagatu, Mr. P. Nongri, then counsel for the
Party number 3.
respondent number
Number 3, Lordship.
2 and 3,
No, 3 only.
respondent number 3, who has submitted that a show cause to the application for continuation of delay filed by the applicant, Project Director, National Highway Authority of India, has been filed for this court. An affidavit has also been filed to bring on record certain documents which are required to be considered by this court when this application for continuation of delay is taken up for consideration. I know next Ms. P. Charji, the head counsel for the applicant, has submitted that the copy of such of the said show cause and affidavit has been received. It is prayed that some time may be allowed for this matter to be heard on merits. Answering your name? Andre? Frankly, hearing matter? Lovely. Apparently. We'll take it up on 18th,
18th,
Friday.
Your Lordship. Next Friday.
This is matter on 18th. So 18 then? Fine.
Obliged.
Item number 2.
Please, my lords. Lordships, the survey report by the state has come, Lordship. They had filed it yesterday.
Your Lordship.
Lordship, if I may be permitted to file a...
Is there any order to that effect?
Lordship, there
Yes, Your
is...
Lordship. Order dated 26/6/2025, Your Lordship. Passed in Miss Case number 164 of 24.
This case?
164 of 2024, Your Lordship.
Hey, the order sheet. Okay. One 164. Can you none order sheet? David. Okay, Shamo can you get 114? 2000.
If I may assist your Lordships, Lordships may come to the order passed in the main case, Lordship, order dated 05/12 of 2024.
Sorry, I've got the order in the main in this case. Order
Lordship,
dated
Lordship,
26/6/25, Your Lordship.
26.
The last order, Your Lordship.
Oh, this was with reference to the earlier order
the
passed.
earlier order
Your
is
Lordship.
passed. Yes, Lordship.
We filed the report, Your Lordship, yesterday.
Okay, okay.
Lordship,
So,
if I,
what do we do?
at this stage, Lordship, I'm praying if I may be permitted to file a short objection, Lordship, to this affidavit.
I don't think any objection required.
Lordship, it does require, Lordship,
Because
because
why? They want, this honorable court want to know whether this is feasible for the PWC to do the work.
Lordship,
Because
this aim
what-
has
Please.
interfered in this matter, Lordship, and I may show Lordship to the affidavit that was filed, Lordship, by the state. Lordship,
Court query to know. I don't think any affidavit is needed for this.
Lordship, two factors, Lordship, in this case. There are two factors, Lordship, for consideration. One is that there's a dispute. There's a dispute to the nature and character of the road, which the respondent's aim is claiming to be belonging to him, Lordship.
Nothing in the prayer.
Lordship, it has been recorded. Orders have fallen from this honourable court, Lordship. And the second, Lordship, the second factor to be considered by this court, Lordship, is there have been total mismanagement and misappropriation of funds, Lordship.
Okay.
And the
Okay, you file your response.
Lordship. Lordship, two days' time is... Lordship may have this matter on the 16th, Lordship.
16 is too many matters, I believe, Your Lordship, has been
18.
fixed.
It can be 15 also. It's a short affidavit they can give.
Lordship, 18th, Lordship.
18. Miss Letter Counsel for the petitioner has submitted that the report filed by the state respondent in compliance with this court's order dated 26/6/2025 in MC 164 of 2024 has been received by the petitioner. On perusal of the said report, the petitioner is the petitioner has sought for the petitioner has made a prayer before this court that a response may be allowed to be filed against such report. This court has not produced the said report. However, the petitioner is allowed to file the said response. and the same to be considered on the next date fix. As prayed for, places matter on 18th.
Obliged.
Obliged, Lordship.